There can be acquisition of companies, acquisition of shares, acquisition of managerial rights, etc., etc. They are not concerned. Now they say in para 3 that if it is CIRP, then everyone would be entitled to a green channel. Now, your lordships, may kindly see page 22 of this very page 21, my lord, if your lordships, at the foot, green channel for combinations. My lord, your lordship gets it? Yeah. My lord Justice. In recent times, there has been growing international consensus that mergers are a means of companies to compete and to realize welfare-enhancing efficiencies. Therefore, delaying merger implementation imposes costs, not something is made. I'm sorry, but this is only a heading, a relevant part. But we'll place the entire on record.
There's 1 or 2 pages missing.
No, there are 5 pages, 7 pages, 6 pages missing. The entire is already on record. This is for convenience, my lord. I just give the volume 4, the big convenience compilation, from where I have again, my lord, made a micro convenience compilation. That was prepared by all parties together. But it is very voluminous, so I have taken relevant paras. Your lordships can take it from me. Pages which are missing will not help either them or us. Therefore, we have been careful.
This is volume 4, you said?
Volume 4 of joint convenience compilation. Document number 10. Document number 10. Yes. Yes. I'm thankful, Manoj. I learned it. But your lordships may kindly come to the index of this today's convenience compilation. It mentions, my lord, where in the original record, which is already before your lordships, my lords would find. I'm grateful, Mr. Mehta.
Yes.
So 4.15. Finally, the committee discussed that the proposed green channel must become the preferred route for merger notifications and approval for majority of the cases. It was agreed that detailed criteria for eligibility under the green channel may be formulated by the government based on consultation with the CCI. Appropriate forms for notification under this route may also be designed keeping the aforesaid principles in mind. While discussing the criteria for eligible combinations for the green channel, the committee considered if combinations arising out of IBC should be permitted to pass through this green channel. Now, Lord, IBC specific recommendation. The IBC involves an insolvency resolution process wherein a company going through insolvency may be taken over by another enterprise whose plan is approved by a committee of creditors of the insolvent company. This gives rise to possible combinations, and the applicants proposing such a plan, that is resolution applicants, are required to notify their proposed combinations to the CCI if requirements of section 5 of the Act are met. The committee discussed that the insolvency resolution process is a time-bound process and combinations arising out of this may require quick approval. It was noted that the IBC was enacted with the aim of minimizing the volume of non-performing assets in India. One of the objectives of the IBC is to create a market for distressed assets to maximize the value that creditors of distressed firms will receive. Please mark, value maximization is yet another heart and soul of IB code, apart from the company remaining a going concern. It was highlighted. It was highlighted that since the policy objective here is to boost the distressed asset market, it may be beneficial to ease the regulatory burden on resolution applicants. It was thus concluded that combinations arising out of resolution plans under IBC may be notified through the green channel. Now, based upon this, Lord, CCI regulations are amended, which your lordships would find at page 24, Lord, at 25. But again, only relevant extracts, Lord, not entire regulations. Yes, ma'am. May I? Yes, ma'am.
It could be complete if you also read F4 5.1 on page 23.
23.
No, you finish reading page 22.
5 point, Manoj?
5.1.
I'll
That is
read 5.
paragraph 5 deals with deal value threshold for combinations.
Yes, ma'am. Manoj, this is not for IBC, for other general.
Then one of the sentences.
Yes. During its discussions on combinations, the committee observed that in the last decade, the 5 largest technology companies have made over 400 acquisitions globally. As noted by recent report, some of these acquisitions have been exceptionally high value, peaking with Microsoft paying $26.2 billion for LinkedIn. The committee was appraised by the CCI that industry leaders have recognized the imperative need for ex-ante assessment of acquisitions in digital space during a stakeholder consultation on digital markets and competition issues organized by CCI on 24th July. The CCI further informed the committee that CCI has set up a think tank comprising of technologists, economists, and lawyers to deliberate on the issues that arise in a new age markets. In a meeting held on November 18, all members of the think tank appreciated the need for looking at acquisitions in the digital space more carefully. Regarding acquisitions outside the IBC. The committee discussed that most of these acquisitions are in digital markets derive value from data or some business innovation held by the target. If such acquisitions, the target may not have a huge asset base and may be offering products or services that are either free or generate insignificant turnover. For example, Twitter, the acquisition of Twitter by Elon Musk. There are no assets. It's the value of the product which is the value. This may be because the business model of companies in digital market is often such that they do not generate any significant revenue for a number of years, focusing initially on user growth. In such circumstances, the value of target sale is a rather poor indicator of transactions' significance for competition. Against the background, the committee discussed the adequacy of existing asset and turnover-based threshold for notification of combinations provided in Section 5 of the Act.
Yes, please come to the other thing.
This was for different contingency outside IBC. Then, in view of this, section, this regulations, at page 24, Competition Commission of India, but if your lordships can, take the act, bare act, instead of, reading it from here. So please take the bare act,
Competition Act.
Competition Act. So please see the definition, my lord, at 2R. When I say that this would eliminate those who are real players in the relevant market. Therefore, my lord, I'm showing 2R of the Competition Act. That your lordships may consider interpreting the provision in such a way that regular players, my lord, who are in the relevant market are not eliminated, because they are not getting green channel, which they are not getting right now. There is no corresponding amendment in CCA. Relevant market, your lordships gets. Relevant market means the market which may be determined by the commission with reference to the relevant product market or the relevant geographic market or with reference to both the markets. Then relevant geographic market, my lord, is defined. Relevant product market is defined. And now your lordships, my lord, kindly come to section 5. I'm just showing the scheme. I'm not either supporting or defending or objecting to the order passed by CCA. That is for, I'm not even a party. I'm just showing the scheme for my purpose of interpreting the proviso. That's the limited purpose. Combination, 5 combination. The acquisition of one or more enterprises.
You're reading what?
Section 5 of the Competition Act.
Yes.
I have shown the relevant market player, product wise and geographical wise. Means someone who is already there in the market. Acquisition, combination. This applies to combination. Combination is defined. The acquisition of one or more enterprises by one or more persons, or merger or amalgamation of enterprises, shall be a combination of such enterprises and persons or enterprises if any acquisition where, etc., can be amalgamation, merger, takeover, etc., any kind, which results into what is described as appreciable market impact.
Where is that?
Section 6, answer.
No.
Section 6, subsection.
It's the
Regulation of combination.
prohibition.
No person or enterprise shall enter into a combination which is or is likely to cause an appreciable adverse effect on competition within the relevant market in India, and such a combination shall be void. So, to come out of this, you will have to pass through the approval route of the Competition Commission, so that you do not become a monopoly and you do not impact the market adversely. The intention is that the consumer may not suffer. As I have given the example, suppose the Pepsi were to take Coca-Cola, then 80% or 85% of the market would be captured by one entity, and that they can change the prices the way they want, and consumer will suffer. Therefore,
if Coca-Cola is taken over,
yes,
the Mirinda devil will, have a swig and say,
yeah. Now, my lord, please come to, my lord, the regulation. 6.2 also. Subject to the provisions contained in subsection 1, any person or enterprise who or which proposes to enter into a combination shall give notice to the Commission in the form as may be prescribed. Please mark this, my lord.
Specified.
And specified, and the fee which may be determined by regulations disclosing the details of the proposed combination after any of the following, but before consummation of the combination. Then A, approval of the proposal relating to merger or amalgamation referred to in clause C and clause D of section 5 by the board of directors of the enterprises concerned with such merger or amalgamation as the case may be, and execution of any agreement or other document for acquisition referred to in clause A and clause D of section 5 of acquiring control. But B is considered, resolution plan is considered to be this document, agreement. When the trigger point, of a resolution applicant approaching the commission is at 6.2b, when he files his resolution plan. This is my plan, which may potentially have the effect of combination, which is not permitted without your approval, and therefore I am applying. Now, my lord, the application will have to be under the regulations, which your lordship would find at page.
But all this is independent of the IBC regime.
Correct.
If there is a combination otherwise happening, somebody is
They have to
proposing
go
to
through.
enter into, then this is the route they will follow.
Yes, even IBC they have to follow.
Correct. No, but this particular provision,
It's the generic provision.
it's that's right. So
Yes, it's not for
nothing
IBC
to-
specific.
Particularly to IBC.
No.
Yes.
In fact, that is the problem, my lord. The regulations were amended. Act is not.
Yes.
Well, now please come to the regulations, my lord, at page 164. My lord, if we have, my lord, the same copy, my lord, it is Competition Commission of India, procedure in regard to the transaction of business relating to combination regulations.
Not have much impact. This is the example, the word
Give me, I'll read from the old act. My lord, nothing turns on that. my lord.
before the, it may turn, but before the.
Let me read, I'll not.
Consummation, combination, words added afterward. Old Act,
You are referring to section 6?
six was. There is an amendment in 2020, with effect from 2024.
Just a minute.
September 24, it comes into effect. So obviously, it won't apply to us. Lordship takes the. Can I just hand over this?
But, what I read,
May I just make it simple?
my copy is
Proposed combination within 30 days of.
this copy.
And the new one is shall give notice disclosing the details of the proposed consummation after any of the following, but before consummation.
It's
That
30
is
days of.
2011.
It is 2011 amendment.
Yes. I don't know, but I'll take whichever copy my learned friend wants me to take. Because for my case, nothing turns on that. Man. I always prefer the latest version. Man. Mine is 24 edition. You give me that copy.
I'm saying something here. I am told, well, I'll also have to check up, that this is an amendment of Act 9 of 2020, effect from 2024. The 2011, earlier one. But let me check up the correct books, because there may be something, nowadays there are also lots of problems also. As far as I can see, this is Act 9 of 20, it changes section 7, which adds these words.
Undisputably, 2022 edition, according to you, is the correct. 22 is correct. My lord, I'll read from 2022. My lord, for me, it doesn't make any difference. Because whatever may be the amendment, then let us read the unamended part. Because I have-
But we know what the amendment is. It's literally.
You may read it so that we understand what was the added thing.
Yes. My lord, added thing means, my lord, we may have to go through, my lord, the amended copy.
No,
So that,
within 30 days or something. Anyway,
It says instead of after any of the following but before consummation, you have to read within 30 days of.
Yes.
Yes, after that. He's against this word before consummation. It is not there.
I'm not, my lord, raising my argument on that it can be, it's only inform and proceed regime. That's not, my lord, my case. Now, please come to, my lord, the regulations. But the regulations, my lord, are your lordships have the regulations, my lord.
yeah.
No, please come to 5, regulation 5. Form of notice for the proposed combination. Any enterprise which proposes to enter into a combination shall give notice of such combination to the Commission in accordance with subsection 2 of section 6 of the Act and these regulations. The notice under subsection 2 of section 6 of the Act shall ordinarily be filed in Form 1, please mark this, as specified in Schedule 2 to these regulations duly filled in and accompanied by evidence of payment of requisite fee by parties to the combination. Notwithstanding anything contained in subregulation 2 and without prejudice to the provisions of subregulation 5, the parties to the combination may, at their option, give notice to in Form 2. Now, Form 2 is for those who have presence in the relevant market. As specified in Schedule 2 to these regulations, I'll come to that. To these regulations, preferably in instances where the parties to the combination are engaged in production, supply, distribution, storage, sale, or trade of similar or identical or substitutable goods or provision of similar or identical or substitutable services, and the combined market share of the parties to the combination after such combination is more than 15% in the relevant market. So this applies to the people already in the relevant market. In case of Pepsi, Coca-Cola, if suppose Arvind Denim is to enter, he need not go through Form 2 because he is not going to be dominant in the relevant market. The parties to the combination are engaged at different stages or levels of production chain in different markets in respect of production, supply, distribution, storage, sale or trade in goods or provisions of services, and their individual or combined market share is more than 25% in the relevant market. So again applies to the person already in the relevant market. The parties to the combination shall give notice in Form 1 or Form 2 as the case may be in accordance with notes to Form 1 and Form 2 issued by the Commission and published on its official website from time to time. Where in the course of inquiry it is found by the Commission that it requires additional information, the Commission may direct the parties to the combination to file such additional information, provided that the time taken by the parties to the combination in filing such additional information shall be excluded from the period provided in subsection 2A of section 6 of the Act, subsection 11 of section 31 of the Act, and sub-regulation 1 of regulation 19. Having due regard to the provisions of sub-regulation 2 and 4, in cases where the parties to the combination have filed notice in Form 1 and the Commission requires information in Form 2, from its prima facie opinion that no, you are in the relevant market, you are wrongly come through Form 1, where the combination is likely to cause or has caused appreciable adverse effect on competition within the relevant market, it shall direct the parties to the combination to file notice in Form 2 as specified in Schedule 2 to these regulations. But this would show to your lordships that if I am not in the regular market, Form 1, which is simple form, which I will file, and which now becomes a green channel, and for if I am in the relevant market already, then I will have an exhaustive form to be filed, that is Form 2. Then, if the requisite details are not available for any of the columns in Form 1 or Form 2, the date on which they may be submitted should be clearly indicated against those columns by the parties to the combination, provided that the time taken by the parties to the combination to submit the requisite details shall be excluded so and so. The report which I read, 5A.
Yes.
For the category of combination mentioned in Schedule 3, mark that, my lord, I'll kindly mark that, I'll take your lordship to that schedule. The parties to such combination may, at their option, give notice in Form 1 pursuant to Regulation 5 along with declaration specified in Schedule 4. So they have been now given a green channel. My lord, what has happened, just bear in mind.
Yes.
The successful resolution applicant in this case is a big player in the relevant market. Therefore, he went through Form 2. My learned friend's client is not in the relevant market in India, and therefore he filed Form 1. So he got the approval before the COC, and the successful resolution applicant got the approval at the time when adjudicating authority was decided. Is yet to decide, but when adjudicating authority came to be possessed or seized of the issue under 31 subsection. That is not the idea. That is not the factual position. Now, kindly see. Upon filing of a notice under subsection 1 and acknowledgement thereof, the proposed combination shall be deemed to have been approved by the Commission under subsection 1 of section 31 of the Act. Provided that where the combination finds, the Commission finds that the combination does not fall under Schedule 3 and or declaration filed pursuant to subregulation 1 is incorrect, the notice given and approval granted under this regulation shall be void ab initio, and the Commission shall deal with the combination in accordance with provisions contained in this part. If you go through a green channel, so to say, wrongly, and if you are caught, then it would be void ab initio. Provided further that the Commission shall give to the parties to the combination an opportunity of being heard, etc. Now, please come to Form number 1. Page 180, if the Honorable Court, and I'm not going to read the entire form. This is under Regulation 5.2. Your Lordships gets,
Yes, Form 1.
Form 1. Lord, kindly see clause 7 of Form 1. Whether the notice for the proposed is under green channel, you have to say yes or no. I come to what is green channel. Then your Lordships may come to Form 2.
This is applicable for the green channel category.
For both.
Those who are not present in market.
For both, but they will have to say that I am not in green channel or I am in green channel.
The form is a common form.
Common form. Then Form 2. This is more comprehensive form, where I am definitely, even according to me, I am in the regulated, I am in the relevant market. So I have a market presence. Therefore, it says Regulation 5.3. Correct, Manoj? Now, your Lordships may kindly come to page 196, which is Schedule 3. But if I want to take advantage of amended Rule 5A, Regulation 5A, I have to, would your Lordship like to see 5A again, so that your Lordships can connect why I am showing Schedule 3? I want, my lords, to take 5A route, which is a faster route, which is green channel. 5A is green channel.
Yes.
The Lordships have 5A, just for my satisfaction. Thereafter, kindly have Schedule 3.
Page.
168. This is the green channel, but this is after the report which I read before your Lordships, the amendment made in 2019.
Yes.
For the category of combination mentioned in Schedule 3, the parties to such combination may, at their option, give notice in Form 1 pursuant to Regulation 5, along with declaration specified in Schedule 4. And if you wrongly go, then there is a consequence. Now, please see, Schedule 3 at page 196. Those who are entitled to
No, so you have to choose whether you are giving in Form 1 or Form 2.
No,
Or everybody has to give in Form 1 only. Initially.
First, they have to choose. But now a new route, that is green channel, is created.
This was created in 2019.
19, that is 5A, but only for those which fall under Schedule 3.
Yeah.
Now, Schedule 3 is at page 196. And they have to give a declaration as specified in Schedule 4. Now, your Lordships have Schedule 3 at page 196.
Yes.
considering all plausible alternative market definitions, the parties to the combination that respective group entities and or any entity in which they directly or indirectly hold shares and or control, A, do not produce or provide similar or identical or substantial products or services, are not engaged in any activity relating to production, supply, distribution, storage, sale and service or trade in products or provisions of services which are at different stage or level of production chain, and are not engaged in any activity relating to production, supply, distribution, storage, sale and service or trade in products or provision of services which are complementary to each other. So if you yourself can certify that I am not having any adverse market effect in the relevant market, then I can file it under, then I would say that I fall within Schedule 3 and I will file my form mentioning that I am in a green channel. But what declaration I will have to make is Schedule 4. The notifying party confirms that it has furnished all the information and documents as required in Form 1 as specified in Schedule 2. The notifying party confirms that the proposed combination falls under Schedule 3 and is not likely to cause adverse effect on competition. So if I am already in the relevant market, I cannot choose this route because I cannot falsely declare that I fall within 5A and therefore I fall within Schedule 3 because I already have my foot in the relevant market, and my entry or my acquiring the resolution, the company under resolution would affect the market adversely, likely to affect the adverse mind. Well, that is why I respectfully submitted that if their interpretation is right, then considering the time lag, which I will not come to between this Form 1 channel and the green channel, all people who are in the relevant market will be out. Because match the timeline of producing approval of Competition Commission before the COC takes a decision, though they can produce it when the adjudicating authority is taking a final call.
You're sure of that?
Yes, I have the chart for them. The chart, showing the time limit for Competition Commission, Competition Act, and time limit under the IBC. And therefore, I started by saying that there are two fundamental aspects of the IB code. One, company must remain a going concern. Bata Shoes taking over a pharmacy is less likely to keep the company going as compared to some other pharma company taking over the company. So the combination issue will be there. But if the timeline is to be matched, then they will not be able to match the timeline. And those who are really viable, really feasible, and really will not achieve the object of that will remain out. That is the problem. And second is value maximization. But the person in the same relevant market is likely to give more by way of value maximization than the person who is a new entrant in the market. So what has happened is the other Dr. Singhvi's client, he went through the green route, the green channel, and he got the certificate early before the COC decided. The other side, Mr. Rodki's client, they had the presence in the market, in the relevant market, namely the glass market. So they could not file this Schedule 3 declaration because they were not falling within this. So they had to go through non-green channel route, and therefore they also ultimately got the approval. But not at the time when COC took the decision. COC approved them subject to the approval. But they had the approval when it was filed before the adjudicating authority. Now, coming directly to that.
In the manner these particular provisions have played out, for those who are not present in the relevant market, for them it is predestined practically that their approval will come well ahead of the competitor resolution applicant who is already present in the market because he has to have a more detailed scrutiny, suffer more detailed scrutiny.
So that is being done by the competition board. So they have a different criteria for that.
They have different criteria. So therefore, my limited submission is that please accept the requirement of approval of the commission as a mandatory requirement, but not at the stage of COC, at the stage when the adjudicatory authority decides. So that's the only way a workable reading can be made. Otherwise, it would, in my respectful submission, destroy the very intent and purpose by keeping the relevant party out of the race and giving undue leverage to those who are new entrant to that particular field, the field in which the company under insolvency is dealing in. Therefore, for that purpose, I took your lordships through the scheme of the court.
Examples Mr. Mehta is giving us: soft drink, medicinal, pharmaceutical. Suppose a Jamaican company would have come with, let us say, an alcoholic popular beverage found there to enter into the glass industry, then there would have been less difficulty.
Yes.
But a glass industry man is coming here.
Yes, they, I think, also have some presence in the glass industry, but elsewhere, not in the Indian relevant market. Therefore, they, though.
But here the logical thing would have been that since glass is already here, you come and pour what you are.
What glass is meant for?
Yes.
Yes.
There was another argument that these, what you said, IVOF and all that, for that to obtain the approval, you gave some wrong details also. Some kind of an argument was that.
I am not. I am for the COC.
I mean, we are not saying here. But
if that is so, in Regulation 5A,
5A, with the same penal provision or whatever.
Obviously, it would apply to everyone. I can't defend it. I am not here to defend the successful resolution applicant. If he has given some wrong information, the consequences stipulated under 5A must follow. I am on interpretation of the proviso. I am not whether A succeeds or B
He
succeeds.
didn't give the wrong information through Form 1 route. No.
No, Form 2.
Form 2.
He filed a Form 2.
But to get that condition, probably maybe. So, strictly speaking, it will not apply, but it should apply. Something should apply. If it is found that details were wrong.
Very honest, I have not examined that because I was very clear that I am not either defending them or opposing them. I am concerned with the interpretation of the proviso. As a COC, why should I enter into their internal dispute? If they have misled the commission, they have misled the commission. Consequences will follow. Or if they have not misled it, for Mr. Rodgi to say, but I am not.
Mr. Rodgi will argue.
So we are. CI has a number of occasions. That will clarify.
Sure, they have some justification for the allegation made, but I am not going into it because I am not concerned with it. Now, please, my lord, kindly have a look at the comparative chart which we have prepared, my lord, between page 29 of my, details of my convenience compilation filed today. Your lordship gets, my lord, there is a horizontal chart. And I have taken the timeline stipulated under the code and the act respectively. So there may be cases where there is an extension granted or not granted, but when your lordships are examining the law, my lords would go through the provision as it stands, the timeline as it stands. Not the top, there is a line in the middle. The top is Competition Commission. and the bottom is the timeline in case of IBC. First take IBC, my lord, from left hand side. Does my Lord Justice Roy get, my lord?
There is a flow chart.
Yes, my lord.
This is called flow chart of timeline.
Yes, my lord. Lord, there is a line in the middle, the
Green line.
green line in the middle. Green line in the middle. I'm sorry, I have a zero. And the upper part is the timeline of Competition Act, and the lower part is the timeline of IBC. And I have tried to, my lord, reconcile, and I am unable to reconcile. That's my submission, that if your lordship reads shall as may, while holding that approval is mandatory, but not at the stage of COC, even if it is at the stage of adjudication,
Let us go.
then,
to
my lord,
because, yes, yeah,
it
let us
becomes
just-
workable. That's the submission. Lord, first see, my lord, the bottom.
Bottom.
Day 0, CIRP commencement. Lord, I file an
This is
application.
IBC. Bottom is IBC.
Bottom is IBC.
Yes.
Lord, I file an application under section 7, section 9 or section 10. That is day 0. Then publishing of EOI. So that is
Expression of
statutorily
interest.
stipulated to be 60 days. But I am cutting all, my lord. That notice is issued, hearing, admission, etc., my lord. Day 0 is admission. I stand corrected. But day 0 is, before that, I have already filed. The adjudicating authority, NCLT, has applied its mind, and my application is admitted. So CIRP commencement date.
Commences from that stage.
Commences from that. That's the statutory provision. From the date of admission, the CIRP commences. Then, my lord, within 60 days of that, the interim resolution professional will have to issue EOI, expression of interest. Then, within 105 days from, my lord, the first day, he will have to issue RFRP. Yes, request for resolution plan, my lord, RFRP. Then 135th day is the date on which, my lord, everyone will have to file the resolution plans. But I hope, my lord, I am able to make myself clear. But now, my lord, when I file my resolution plan, I am, my lord, hypothetically a resolution applicant. My lord, on that day only, my lord, I can approach the Competition Commission. Now see the top line. Notice to the CCI, form number 1 or form number 2, section 6.2, read with regulation 5.2 and 3. So, my lord, my Competition Act day starts from 135th day of IBC. Before that, I cannot apply because there is no resolution. Then, my lord, kindly go further, my lord, or form 2 filing, when the form 1 is filed, but CCI is of the opinion that information need is filed in form number 2, needs to be filed, or, my lord, other cases which are not in Schedule 3. The lordships have seen Schedule 3 cannot resort to green channel, my lord. So, my lord, that would take, my lord, I can file either of this, my lord, on the first day. Thereafter, there are 30 days for the CIC, for the Competition Commission, CCI, to form a prima facie opinion that if there is any appreciable adverse effect. But so far as form 1 is concerned, that process will not go on because there is no adverse impact. Because he is not in that relevant market. That's the declaration he has given. He is in form Schedule 3. So this would apply to those who are in the relevant market. The CCI will take 30 days, 30 working days, my lord, again. 30 working days, my lord. I have examined, my lord, from consulted some officer from the CCI. What is the difference between tender days and working days? The difference is they have a provision for freezing the days in the sense, my lord. Suppose some particular thing is required to be done in, say, 30 days, for which notice is required. I came to conclusion prima facie as a Competition Commission that there is a likelihood of adverse impact, and therefore I'll issue notice. I come to know on 1st of January, I issue notice on 7th of January. Then the 30 days period freezes. Then they will come, they will explain